The Karnataka High Court on Tuesday, 15th March, has delivered its much-awaited verdict in the petitions filed by several Muslim girls asking for protection of their right to wear hijabs in classrooms in educational institutions in Karnataka. Now, the court has dismissed all these petitions. It has said that no, there is no need for a protection of these girls. There is no question of them having a right to wear the hijab in classrooms. There is no need for further protection. And it has upheld a government order which talked about the prescription of uniforms. I'm going to read out now what the court actually said. The bench, which is Chief Justice Rituraj Avasthi of the Karnataka High Court, along with Justices Krishna Dikshit and J.M. Kazi, they said, and I quote here, "We are of the considered opinion that wearing of hijab by Muslim women does not form a part of essential religious practice in Islamic faith." They then go on to say the prescription of school uniform is only a reasonable restriction that is constitutionally permissible, which the students cannot object to. Now, why is it the court has why are these the two sort of key findings which the court had to make? That's because the big legal issues before the court were that, okay, these girls are saying they want to wear the hijab, schools are saying there are restrictions. Now, is the right of these girls to wear the hijab, is it protected by Article 25 of the Constitution, which is your right to profess and practice your religion? Now, the thing is that when it comes to that right, if you're talking about a practice which is an essential religious practice, the Supreme Court has held over the years, that in those cases, then the restrictions imposed by state authorities on that have to be subjected to a great deal more scrutiny. They have to be, there's a lot more analysis of whether or not this is, required. Are the measures proportionate? All of that. And, if it's not an essential religious practice, however, then there are no real sort of limitations on the restrictions that the government can impose. The second key argument here, which was raised by the petitioners, was that, look, leave aside the question, even if you leave aside the question of an Article 25 right to wear the hijab, we also have the right to wear that as it's a matter of our clothing. That comes within your right to freedom of expression and freedom of speech under Article 19(1)(a), and also of your right to privacy. Now, the court had to then say that, okay, maybe this is your right, but then also, as you might know, fundamental rights can be subjected to reasonable restrictions. That's within our constitutional scheme. So are these uniforms, when they're imposed, are they reasonable restrictions or not? And the court has held that, actually they're perfectly reasonable. Now, how have they arrived at these conclusions? So first, when it comes to the essential religious practices test, they went over what was decided in a bunch of cases over the years in the Supreme Court, leading finally to the Sabrimala judgment, where a set of criteria were laid out for what constitutes an essential religious practice. And then once they looked at that test, they felt that in the end, the wearing of a hijab does not quite arrive at that. And I'm going to quote here. They say, "This apart, it can hardly be argued that hijab, being a matter of attire, can be justifiably treated as fundamental to Islamic faith. It is not that if the alleged practice of wearing hijab is not adhered to, those not wearing hijabs become sinners, Islam loses its glory, and it ceases to be a religion. Petitioners have miserably failed to meet the threshold requirement of pleadings and proof as to wearing hijab is an inviolable religious practice in Islam and much less an essential religious practice." Now, the reason why they went into these issues was because, as we said, the Sabrimala judgment laid down this test. So one of the, so the factors which you have to look at to decide an ERP are, okay, is this something which is fundamental to the practice? If you take it away from the religion, does that affect the fundamental, does that fundamentally affect the way the religion is practiced? And, if a person who belongs to that faith doesn't actually perform that practice, what are the consequences for them? Are they going to be excommunicated? Are they going to be considered to not be Muslims? And they found, after going through, a number of references to the Quran, from authorized translations, which have been accepted by the courts in the past, they felt that this was not the case at all. That therefore, the standard for an essential religious practice was not met when it comes to the wearing of hijabs. The next point, which obviously then came up, was, okay, what about the right to expression and your right to privacy? You have a right to choose what you want to wear. Why should that be restricted? Why should a girl be told you can't wear a hijab? Now, obviously, the standard issue of whether, there are reasonable restrictions possible on these things, that came up. But there are tests for deciding, are these, reasonable restrictions or not? Are these restrictions constitutionally valid or not? We have the test of proportionality. We have the test to look at even, whether something is discriminatory, is it manifestly arbitrary? There's a whole set of tests and scrutiny which can be conducted by the courts. What is strange here is that the court actually just ignored all of that. It said that we don't need to get into these tests because, and this is the slightly strange thing, I'm going to read out again what the court said. They said that the petitions we are treating do not involve the right to freedom of speech and expression or right to privacy, to such an extent as to warrant the employment of these tests for evaluation of the argued restrictions, which are, the school uniforms. Now, this is very bizarre. There's no reasoning provided for this. There's no legal precedent provided to say that, if you're talking about kids wearing uniforms in school, that's not really exactly an issue of the freedom of expression or the right to privacy. They've not cited any authority for this. They've just sort of arrived at this conclusion on their own. They say that, you're dealing with a qualified space because you're in a school and uniforms can be prescribed there, and so therefore it's perfectly okay, and a uniform is a reasonable restriction. This is despite, the Karnataka girls, lawyers for them arguing that, we're not saying we won't wear the uniforms, we'll just wear the hijab in the same color over the uniform as well, and it's just a scarf, right? It's not a whole full body thing. And yet the judges just rejected all that. They've got this very strange obsession with uniforms. They first said that we cannot comprehend schools without uniforms, which is strange. They also say that if students start getting to decide what they could wear, this will lead to chaos on campus and also society at large. So very strange obsession with uniforms here by the judges. But the lack of reasoning here is something which could likely be taken up on appeal at the Supreme Court, which is where we know this is going. The final, key point to address in these was when they looked at the government order of 5th February and said this is perfectly okay. And the main issue here was, how can a government order say that students must not wear something which could disturb public order? Because that's a very technical term. Public order, you've got decades of judgments of the Supreme Court talking about how that's about incitement of violence, that's about something really serious. It's not even just a law and order problem. So what on earth are you doing by saying that students mustn't wear clothes which are going to disturb public order? And the strange thing is that instead of saying, that's a bit of a nonsense and that part of the order can be scrapped, the court actually says, but you shouldn't interpret public order there the same way you do in a statute or, when the courts normally look at it. And that is a very, very strange thing to do because, again, that doesn't make a lot of sense. This is a government order. This is not some school person writing an essay. It's a government order. It's using specific language. Why is that not being interpreted the way it should be? And, you even had the Advocate General of Karnataka coming up before the court and saying that he agreed that the draft of that order was a bit overzealous. And the court still thinks this was perfectly fine. So another very strange thing which could likely become an issue on appeal. Make sure you follow the Quint for all those updates of what's happening in Karnataka right now in response to this, whether it's political reactions or the reactions of the students and the girls who are now being told that they have to, go to classes without wearing a hijab. And of course, as this legal case proceeds, the challenges which will be taken up in the Supreme Court. So keep following the Quint for all those updates. We will be making sure to give you all of it.